39 of the Criminal Procedure Code. So, and if you permit me to read, a magistrate may at any time arrest or direct the arrest in his presence within the local limits of his jurisdiction of any person for whose arrest is competent at the time and in the circumstances to issue a warrant. In summary and simply put, Section 39 of the CPC permits you to cause the arrest of person or persons who are within your jurisdiction, and the parking behind you where these three gentlemen are is within your jurisdiction. You can cause them to be brought here under your own arrest, then you grant them bail. Then the prosecution can take their time to reflect on whether they want to charge them or not. I don't think that it is, this is not a habeas corpus application we are making so that one suggests that we should go to the High Court. It's not.
Yes.
How much more?
Yes, perhaps, if I may just finally here and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. Your Honor, further, subsection 2 states as follows: the application contemplated in subsection 1 shall only relate to rights guaranteed in Article 25A and B of the Constitution. If you permit me further to elucidate what Article 25 states, Your Honor, what is most critical here is Article 25A. It says that despite any other provision in this Constitution, the following rights and fundamental freedoms shall not be limited. It says that A, freedom from torture and cruel, inhuman, or degrading treatment or punishment. Your Honor, it cannot be gainsaid that the three arrested persons are undergoing extraneous levels of cruel treatment that are against our Constitution. Your Honor, we would be reminded that we are under Article 4 of the Constitution. Article 2 of the Constitution, Your Honor, we have the International Charter on Civil and Political Rights that speaks against inhuman and degrading treatment. It is our humble plea, Your Honor, that this court cannot fold its hands in light of the grave violations by the state. We are humbly imploring on you to take judicial notice of the times we are living in and render justice and give light and voice to the Constitution 2010. That is all.
My police condolences to the entire country for the loss of beloved sister magistrate. And when we find time, just
before me, by learned senior counsel Haron Dubi and several of his colleagues, for me to make an order for the production of certain arrested persons, including one Boniface Mwangi, for mention, and for me to grant them bond terms if the state is unwilling to charge them. It has been alleged that the said arrested persons are in a motor vehicle within the precincts of this court. It has been submitted that this court is clothed with jurisdiction to cause the arrest of these persons or of persons within its jurisdiction or within its vicinity under certain circumstances. It was also submitted and argued that the court has powers to hear applications for redress and infringement of fundamental rights, freedoms and rights guaranteed under Article 25A and 25B of the Constitution. In response to the application, the prosecutor indicated that he is not aware of any persons allegedly held as submitted within the law courts and has not received any indication from the headquarters of any such persons that were supposed to come to court for plea. He suggested that the applicants ought to file the application before the High Court for habeas corpus. The court has considered the application made by senior counsel and his colleagues, and the submissions that have been made. I will start by clearly stating that this court has no jurisdiction to issue orders that have been sought for the following reasons. Number one, the nature of orders sought, in my view, are habeas corpus orders, and habeas corpus orders which applies to all cases of illegal confinement or detention by which a person is deprived of his liberty or by which the rightful custody of any person is withheld from a person entitled thereto. The ultimate purpose of such writs is to relieve a person from unlawful constraint, which is the case presented before this court. The procedure for directions in the nature of habeas corpus is well known. It is through a petition before the High Court for enforcement of the rights under Article 51(2) of the Constitution. The court has been invited to issue a warrant of arrest. The court was also invited to issue a warrant of arrest for the arrested person so that they may appear before this court. But I find this to be unprocedural, as the said persons are still under arrest according to the submissions that were made, and the court cannot issue warrants of arrest for persons already under arrest. The correct procedure is for the counsels to proceed with the right procedure before the High Court. It is also noted that this court there is no file before this court with the specific parties, the names of the parties involved. For the court to give specific orders of the nature sought, a court file must be opened, after which the application can be made. And noting that we are in an adversarial system, the same served or the other party notified so that they can respond. So my directions are that the council should follow the right procedure by moving the High Court with the necessary application. So those are the orders for this court.